Okay, we're broadcasting now. Welcome to a fantastic webinar that we've got for you today, and we're really pleased to present Carla Vinchulo to you, our new workplace lawyer who's an expert and got over 10 years experience in big firms and large corporates, is now helping small business with me and the team. And we're really happy to be able to present this webinar today on unfair dismissal, which is what a lot of small businesses get into hot water about. So we thought we'd do our first webinar series, in the workplace area on this, because it's obviously one of the most important. So please let me welcome Carla as our first webinar as well. So go easy on her. Take it away, Carla.
Thanks, Ian. Hi, everyone. Thanks for joining us today. Excited to be talking to you about unfair dismissal. So look, it is just a general information session today. So a little bit of a disclaimer: we aren't giving legal advice. This is just for general information purposes, but obviously we are more than happy to talk to you offline separately later on, because look, every situation is different in this area of law.
So this is going to be a power webinar for you. 30 minutes. We're going to go really fast, so the information is going to come thick and fast to you. But the really main point is, if you do have some specific questions that you need to ask us, write them down and then email either Carla or I later after the webinar, and we can answer them for you. Oh, that reminds me, I should put my phone on silent so we don't get any phone calls during the webinar. Fantastic. All right, well, let's rip through and get underway. We're going to keep this to 30 minutes. So at 12:30 Eastern Standard Time, 10:30 Perth time, we'll keep this as a short and fast pace as possible. Some of the stuff that we're going to be traversing today is going to be just some general law about what constitutes unfair dismissal, but also what are the various factors that are involved, and ensure things that the Commissioner will take into account when they determine what is unfair dismissal, which hopefully will give you as a business owner a bit more practical knowledge and information and a thought process to govern and guide you through that whole situation. But if you ever get into a situation where you think this is probably traversing an unfair dismissal, I want to terminate this employee, then stop. Think about it for a moment before you go ahead and ready, fire, aim, and perhaps talk to us first and just run the situation past us so that you can get a second opinion, because we can all get caught up in the heat of the moment, and that's when rash decisions can often come back to bite us. So if you have any questions about anything that's covered during the course of the webinar, write to us afterwards, and we'll get back to you as soon as we can.
Great. So thanks, Ian. And look, what I want you to take away from this session in a nutshell is having an understanding of what an unfair dismissal claim is. I think we've all heard the term before, but it's really important that we know what we're talking about, that we know what the Fair Work Act says. We're going to look at who can actually make an unfair dismissal claim. Believe it or not, not every single employee is eligible to make an unfair dismissal claim. You might end up being pleasantly surprised that some former employees just can't make that kind of claim against you. And what I really want to focus on is how you can actually avoid an unfair dismissal claim. There's two parts to that. First of all, there's the upfront part. How can you actually conduct your business in a way that means that when someone leaves, they don't want to make a claim against you? And then the back end of how to avoid a claim is making sure that you cross the T's and dot the I's. So if someone does make a claim, you can defend your claim appropriately because you did all the right things along the way. So we're talking about unfair dismissal under the Fair Work Act today. Just bear in mind that in the particular state where you conduct your business, whether that's New South Wales, Victoria, WA, wherever you may be, there is invariably going to be a state industrial relations system and a separate unfair dismissal regime under that state system. But if you're a PTY Ltd company, then you're most likely going to be covered by the Fair Work Act. So just bear in mind that today we are talking about the national system, which is unfair dismissal under the Fair Work Act. So look, without going on too much about what it is, like the name suggests, an unfair dismissal occurs when an employee has had their employment terminated by their employer in a manner that is harsh, unjust, or unreasonable. Sounds straightforward enough, but there's a lot more to it than that.
Yeah, when we were talking before, Carla, we were saying, why is it so important for small business to understand this? And we've sort of worked out that it's really extremely dangerous because small businesses don't usually have an HR department, so they don't usually, or a lawyer on call to provide them with advice as and when they need it for this sort of stuff. So they don't have that resource or as much resources as the bigger businesses have in terms of dealing and managing staff. And usually the bigger businesses will have had experience in dealing with this issue, legal advice in dealing with this issue. So they've got quite a bit of knowledge around the area, and obviously the knowledge is key about working, making sure that you navigate through this sort of minefield, and also payouts being extremely dangerous and potentially, in some cases business ending, but in other cases extremely, putting an extreme amount of stress on business owners, on small business owners, because they simply don't have the budget to deal with, large and expensive payouts, which need to be paid fairly swiftly, I imagine, Carla. Once an order's made.
Yeah, that's right, Ian. So look, unfair dismissal can sound really scary, but look, what I will say to small business owners and sole traders who don't necessarily have the expertise in-house or the financial resources to just pay off an employee to get them to go away quietly into the night, there is some good news here. And the good news is it's really not that hard to follow the rules. The legislation does offer some leniency to small businesses through the small business code. So that's good news, and we'll talk about that more later. But look, the ramifications of a successful unfair dismissal claim are not to be sneezed at. If it goes all the way through to a final hearing, which is like a trial, which happens very, very rarely, but it does happen, the remedies for an unfair dismissal, the primary remedy is reinstatement. So obviously that's not a nice thought, having someone that you've just terminated for whatever reason being ordered by the Fair Work Commission to come back into your workplace. So that's ordered very, very rarely. Yeah. There's usually only 1 or 2 reinstatements a year. So it's pretty much not going to happen, but it is a risk. So we need to bear that in mind. The primary remedy is compensation, money. And the most that the Fair Work Commission can order is either 6 months' salary, or if the salary is over the high income threshold, which is about $138,000, it's half of that. So the 6 months salary, obviously, Ian, for a small business is, that's a lot of money to be ordered to pay out. So and that's at the extreme end, so that's the maximum. So you want to avoid even getting down to the Fair Work Commission for a hearing. You basically just want the matter to go away. And there is a way that you can make it go away. I'm going to give you some information about how to do that. Okay. But what we need to talk about first is what are the things that the Fair Work Commission and the legislation talks about. These are the factors that basically inform how you conduct yourself in any termination of employment to avoid an unfair dismissal claim. The first lap of the race is having a valid reason. You must have a valid reason to terminate the employee. Now, that sounds really, really obvious, but sometimes, believe it or not, we might just not like the look of someone. We might just get a bad sense about them. they might come to work and we just think, you know what, there's just something not right, and I'm not happy. And when it's your business, you know, sometimes you do feel like you've got to go with your gut. But I would just caution everybody to think about a valid reason. And the legislation talks about that valid reason being related to someone's capacity, which normally means their performance or their ability to perform the requirements of the job, or their behaviour, their conduct. So it's really important that you know why you're terminating the person, that it's poor performance or it's conduct. It's also really important that you actually tell the employee why you are terminating them. So you've got to tell them what your valid reason is. Sometimes we don't like to have these confrontational discussions with employees, but they have the right to know the exact reason that you're going to terminate their employment. And you have to give them an opportunity to provide a response to that reason.
And that's all based on legal issues of procedural fairness to a party when you're making a decision against them.
Absolutely. And look, to a certain extent, some of it is common sense. Guys, you do need to obviously give people a chance to know what it is that is the issue, and give them an opportunity to respond and to listen to their response and think about their response and think about whether or not they're raising anything that's valid that you should be taking on board. Do the matters that they're raising, does that change anything? Does it change anything that they've been with you for 5 years? Does it change anything that they have an unblemished employment record with you? Does it change anything that perhaps they're not well, or their child's not well? They're called mitigating circumstances, and the law says that you need to have those factors in mind as well. The next point that I want to make is that the Fair Work Act doesn't require you to tell your employee to have a support person present at the disciplinary meeting that you have with them. However, it is viewed favourably, and if you refuse to allow someone to have a support person, that could be viewed not very well for the business. So as a matter of best practice, my recommendation is, if you want to really cross the T's and dot the I's, invite your employee to bring a support person to any disciplinary meeting that you have with them.
At least give them the opportunity to do so.
Absolutely. And look, to the extent that you're terminating somebody for poor performance, consider whether or not you have previously given a warning to the employee about their underperformance, or if you've spoken to them or given them any kind of feedback, particularly documented feedback, because one thing I've noticed with a number of my clients over the years is that they often come to me and say, "Oh, Carla, look, this person's had so many issues and it's just reached a breaking point now and they've just got to go." And I always say, okay, well, look, just take me through the history. And often what I find is that there's just no documentation that supports what my client's saying. And I believe always what my client's saying, but the Fair Work Commission will want evidence. Like anything, it is a legal framework. So to the extent that you can keep even just a diary note or a simple file note of the occasions that you have even just casually sat down with someone and said, "Look, I'm really not happy with this document you worked on. I expect more." Even just making a simple note of that will really help you later on if you do potentially move to terminate somebody's employment. So previous warnings is a really important factor here, and keeping good records as well.
And I imagine you don't necessarily need to have a written email or an actual document which where this is this is a warning, etc., etc. You can just document it by way of either email, or you can actually put a file note with a date. Who was present. It was just you and them. Performance counselled this person on this day. This is what was said.
That's right. It doesn't need to be. It doesn't need to be a. Sorry, Ian. You're spot on. It doesn't need to be War and Peace. What I've seen a lot of people in small businesses do is they've got a Collins diary that has a day to a page, and they use that diary to simply make notes about these sorts of matters, and that's considered good practice, and that's acceptable evidence as well.
Right.
Okay, so moving on, I want to talk really quickly about misconduct. The reason I want to talk about misconduct is because often what I find is that a number of clients that I've had over the years have described the behaviour of their employee as being misconduct, and they've terminated their employment immediately on that basis, because misconduct is a basis upon which to immediately fire someone on the spot, basically, and you don't need to give or pay out notice for misconduct. The reason I want to talk about it is because I think a number of employees and employers think misconduct is something that it's not. So let's just step through it really quickly, and then I want to touch on some grey areas. Misconduct is not a day-to-day workplace issue. It's not a day-to-day performance issue, and it's not a run-of-the-mill behavioural or conduct issue. It's something that's escalated up from that. It's the next level. It's behaviour that it's intentional or deliberate, in the sense that it's fundamentally at odds with the contract of employment. So it's things like creating a really serious health and safety risk. It's conduct like posting damaging comments on Facebook that are derogatory towards the employer's business. And look, there's a case on that one. There's actually an emerging body of case law that deals with social media. And there's a case called Linfox and Stutzel, which is the leading authority about social media cases. And basically the decision there was that it wasn't unfair dismissal when Linfox moved to terminate Stutzel's employment, because he'd made a number of highly derogatory comments about the business on Facebook. There's some really basic things that I think we all know, like assaulting someone, theft, fraud, intoxication at work. That's all misconduct. But again, I would always urge you to look into the details. Always still avoid, if you can, immediately terminating someone's employment, because it is high risk. If you think that the conduct that you're seeing is misconduct, there's nothing to stop you from potentially standing the employee down on full pay pending the outcome of an investigation into the misconduct. So if it's really serious and you want them out of your workplace, that's fine. You can stand them down, and I would urge you to do that before you shoot from the hip and fire them on the spot. I would also just encourage you to always talk to the employees still about their behaviour and invite them to respond, because there's always two sides to every story, even with misconduct. So we'll move along. Now, I mentioned at the start that not every single employee can be eligible for an unfair dismissal claim, which is the really good news. And I think this is why it's really important to not panic when you receive an unfair dismissal claim. It's really important to actually take a look at the application form or the claim form that you receive, which will be a Form F2, and take a really good look at the details on that form, particularly the dates on the form, and make sure that they match up with the dates at your end, so the date that you terminated the employee. And the reason I say that is because an employee cannot make an unfair dismissal claim against you if they have worked for less than 6 months for you, or in the case of a small business, 12 months.
And what's the definition of a small business?
The definition of a small business in a nutshell under the Fair Work Act is 15 or less employees. So the magic numbers,
mixture of
15.
time or part-time, casual?
Casual employees are not, true casuals are not included in the headcount, but permanent employees are.
Okay.
So I might just pause there, Ian, because I think you sort of got me thinking about something that's really important here, and that's casual employees, because I know that a number of small and medium-sized businesses and startups do use casual employees. Casual employees are those who are engaged as such. They have no expectation of ongoing work or regular work, and their hours are ad hoc, and they're paid a 25% casual loading generally, in lieu of receiving various entitlements like annual leave and sick leave and the like. However, if you have a casual employee and they have worked for you for more than 12 months and they work very regular and consistent hours, and for all intents and purposes look like either a full-timer or a part-timer, then you do run the risk of that casual employee putting up their hand and saying, I'm actually a permanent employee and I can access unfair dismissal, along with a bunch of other entitlements. So just bear that one in mind. But going back to who is eligible to actually file for an unfair dismissal claim, if the employee has only been with you for a fairly short period of time, so like I said, 6 or 12 months, 6 for a business with 16 plus employees, and 12 months for a small business, they can't make a claim. And the other people who can't make a claim are those who are not covered by an award or an agreement, or who earn more than $138,900 a year. So say, for example, you've got a really senior manager in your business and that person is earning $140,000 a year, and that person's not covered by an award or an enterprise agreement. That person earns too much and can't make an unfair dismissal claim. I do just want to throw in another point here. If you have someone in your business who you give benefits to, so by benefits I mean perhaps a petrol allowance or a car, a mobile phone, a laptop, things of that nature, bear in mind that if you can attach a dollar value to those things, which you can, that can count towards the high income threshold amount. So if, for example, you have someone who's sitting at, say, $130,000 per annum, have a think about whether or not you give them any extras that we can tally up to see if they're actually, in fact, when all is said and done, over the high income threshold.
I imagine bonus forms part of that as well.
To the extent, yeah, there are some rules attached to bonuses. There are different types of bonuses. So it would depend on how the bonus is structured. If it's completely discretionary, there may be some challenges. But certainly if bonuses are paid, we should be having a look at that for you and tallying up whether or not that's relevant to add on for the high income threshold test.
Yep. All right, we better keep moving because we've got about 5 minutes to go.
Perfect. Bear in mind, employees only have 21 calendar days to make a claim. So if they are outside of the 21 days, you can put up your hand and say, nope, they've filed it too late, and generally those claims get thrown out. You then have 7 days to file your response as a business. A mediation or conciliation conference will then be listed, and hopefully in the space of all of this happening, the claim is either withdrawn or it's resolved in some way. Very few go through to a final hearing, but that is the final step in the process. So I've been giving you tips along the way, but just to sort of bring it all together, my hot tip is to use your probation period to truly assess someone's conduct and performance. Probationary periods could be anything. It could be 3 months, 6 months, 12 months. But bear in mind what I've said about being able to terminate someone's employment within 6 months or 12 months for a small business. So actually use the probationary period. And if someone's not suitable, terminate their employment before you hit that 6-month point or that 12-month point, because then they can't make a claim against you. Always make sure that if you terminate someone's employment, that you give them written notice of termination of employment. That is a strict legal requirement. I would avoid summary dismissal or immediate dismissal. It's very high risk. You can always stand someone down on full pay, or you can always sleep on it. Shooting from the hip is always high risk. View termination of employment as an absolute last resort. Always think about the alternatives. Can you give a warning? Can you sit down with someone and do an informal performance improvement plan with them? And that doesn't need to be anything complex or anything detailed. It could be as simple as a weekly catch-up and an informal training session. Always get your story straight as an employer. Understand why you were terminating someone and make sure you know whether it's for performance or behaviour. Don't confuse the two. Always give people a chance to tell their side of the story and listen to their story. And if you need to speak to other people, like independent witnesses who may have seen the behaviour, make sure that you do follow up those lines of inquiry. I've mentioned support people. I do encourage support persons to be allowed to attend meetings if that's what the employee wants. And always consider the full picture. How long have you had the employee? Is this the first time? Is this their first offence? If in doubt, give not out, to use an old cricket analogy. Always give people the benefit of the doubt.
What's the danger in terms of terminating for performance or behaviour? What's the take-home point for that?
So I've had experiences in the past where people have alleged that they've terminated the employee for poor performance and poor behaviour. Look, sometimes there might be both factors at play, but it's really important with performance that the employee is warned about their underperformance and given a chance to improve, and that's actually stepped out in the legislation. Behaviour isn't dealt with separately in that same way. It's really important as well to make sure that you're not just throwing everything in the kitchen sink at an employee. If you break it down, 9 times out of 10, it will either be a performance issue or a behavioural issue. It often won't be both. And the reason for that, Ian, is the why it's so important to get it right is because you need to have a valid reason for the termination of employment. And if you can't articulate the reason or the reason's confused, you lose the first lap of the race. And the Fair Work Commission might say, I don't think this is a valid reason. I think you just don't like the person.
Yep.
So we can help you as little or as much as you need to prevent an unfair dismissal claim. My suggestion would be, if you want to keep your costs down and not spend too much money on lawyers, which is always a good thing, I would pick up the phone and have a chat to me before you actually terminate the employee, because getting in place those good front-end strategies is always a good thing. But we can assist you in the Fair Work Commission and by providing any advice that you need in the workplace space.
Yeah, so I guess it's that old stitch in time saves 9 type approach, getting that right advice right from the start, having really good policies in place for the business to make sure that everyone knows where, how they are to perform, and having something to fall back on as well, I imagine, is really, helpful in terms of evidence to say, well, we've got this policy in place. Here is the policy. So the Fair Work Commission will be able to say, well, here is the policy that's provided to you. And it clearly sets out what you need to do, and it's clearly input to it.
Yeah, and Ian, just on that, look, a number of small businesses and sole traders actually don't even have written contracts of employment in place with their people, and I would always recommend that you do have a written contract of employment in place, which sets out some basic obligations and duties and responsibilities on the part of the employee, so that you can then rely on that contract of employment later on to say, look, I actually set out here in the contract what I expected from you, and you didn't meet those standards.
the danger always being that, you know, if you come before a commissioner, you don't have a written contract in place, or you don't have, just like if you don't have terms and conditions for your business in place, when a consumer comes, these tribunals are always very pro-consumer, pro-employee. So in the absence of having this stuff in writing and being very clear, you know, usually, you know, it'll then fall back on you to prove, rather than the other way around. So that's always the approach, and it seems to be really, you know, useful for small businesses.
Look, that's exactly right. And a lot of my advice today has been quite risk averse. And the reason for that is because the Fair Work Commission has increasingly become more worker friendly. So always exercise caution as the employer, because I do think that in today's Fair Work Commission, employers and businesses are a little bit behind the eight ball. So
Yeah.
it's always good to be cautious.
Just to round this out, thanks so much, Carla, for today. It's been excellent, really informative. I know it's been informative for me. There's a few things that I've certainly learned as well, as a result of this, which is great. How we can help in terms of our services that we provide to clients. You know, we've released this webinar is going to go onto Law in a Box, which is brand new. We've just launched last week. We'll be pushing that out to the public shortly. So a whole bunch of information for startups and small businesses. We're going to be building out the particular workplace area with webinars. You'll get a copy of these slides, everyone, after the webinar, as well as a recording of the webinar if you've registered for it, which you obviously are because you're watching it. We'll send you a copy of these slides as well. And if you need to ask us any questions, feel free to give us a buzz, or email either of us. And what we do is also a bunch of packages which help startup and small businesses get some of these key documents in place. So your workplace documents, you know, your contracts of employment, or your independent contractors agreement, depending on whether they're one or the other. Some key documents in place for your workplace areas. If you want to just run through those quickly, Carla, what we can do in terms of key documents for clients.
Sure. I can help you with your contracts of employment, whether for a casual, permanent, part-timer, permanent full-timer, independent contractor agreement, code of conduct, any kind of HR policy, HR document. I really recommend anti-discrimination policies, because having those in place is basically like an insurance policy against vicarious liability. So that's really important. Any kind of advice about award coverage, it's really important to obviously pay in line with the relevant award. We've seen a lot of press lately on penalty rates and things like that. So
even if you want your current contracts reviewed, or if you've borrowed them off Google or some other industry body, and you want to just make sure that they're applicable for your business now, we can do that for you as well.
That's right. Just cast our eyes over those documents and make sure that they're up to date and compliant. And any kind of workplace training, I'm available to come out to workplaces or do online training sessions as well. Any kind of query about union activity that may or may not be present in your workplace, the full spectrum of workplace relations services I can certainly help you with.
All right, guys, we'll wrap it up today. Thanks so much for joining us. Sorry we ran just slightly over time. We really do try and keep it to half an hour to make it as punchy as possible. Enjoy the rest of the day. I hope Easter was fantastic and you're back on track this week and hopefully making headway. We're going to be doing a whole host of these seminars, webinars on workplace stuff, so there'll be much more to come. All right, guys, thanks a lot. Have a good day.
Thank you. Bye.